Hi guys, it's Kathy. I hope you're doing well. Sorry I started my day off with a spot of family drama. It just never ends with them. Never, never. You think they get tired of creating drama all the time, but no, they just love it. They live for it. But I am not in pain. This is maintenance. I have off work for 8 weeks. So I am doing maintenance. I'm not in pain. My hand does not hurt. But I do have a brace on, so just don't worry about it. It doesn't hurt. It's just trigger finger. Like when you move your thumb, it like snaps. And I'm just trying to, I have off for 8 weeks. I should, do some maintenance on my bodies. Okay. We are going to do 2 things today. Opposites. The first thing is just straight up law nerd. We're going to go to North Dakota, and we're just going to nerd out while they try to figure out the new statutes and the laws. I have opinions. Doesn't matter what my opinions are, though. I guess my opinions are pretty mean. The way I feel about it, I guess, is pretty mean. But, oh, Kelly, that's so cool. Put his link up. Is he on Twitch? I watch gamers on Twitch all the time. Let us know his link. We'll watch. We'll watch him. Dude, thank you. I'm working on it so hard. And then the second thing that we're gonna go to the opposite. And nothing crazy happens, but it does. The whole court is just chaos. You'll see what I mean. It's so hard to watch because it feels like the judge is like strict. You'll see him yelling at people, kinda. But it's all chaos. Let's go nerdy first, though. We're definitely going nerdy first.
All right. Barnes County District Court is now in session this December 22, 2025. The time is now 1 p.m. My name is Nick Thornton. I'm a district court judge for the Southeast Judicial District, which includes Barnes County. We're conducting this hearing in part in person and in part by reliable electronic means. The matter on the court's docket, State of North Dakota versus Jacob Allen Ashline, 02-2023 CR 378 and 02-2025 CR 283. Present in court for the state, Attorney Tanya Duffy. Present in court in file ending 378, Attorney Erica Chisholm by reliable electronic means. Defendant Jacob Ashline is present by reliable electronic means in both files. In file 283, Mr. Ashline had previously indicated he was waiving his right to counsel, but intended to hire counsel at a later date. In these cases, a 24/7 warrant was issued following a failure to comply with the 24/7 program. Mr. Ashline, were you present in court when your rights were read to you at a previous time?
Yep.
Do you understand your rights,
Yes.
including your rights to counsel, sir?
Yep.
And you understand you have an attorney present on one of these files, but not on the other?
Correct.
And is that your intention for today's purposes to move forward with Ms. Chisholm representing you on file ending 378, but not on 283?
What's the difference between the two charges? Is it both the 24/7 payments?
It's the same affidavit that applies in both cases because it was a bond condition or a condition of probation in both cases.
That clears that up, guys.
And okay, yeah.
All right. So for today's purposes, the court will consider that a waiver of the right to counsel in file 283. And again, Mr. Ashline, at any time while your case is still pending, you can change your mind and apply for a public defender, or you can always represent yourself or hire an attorney. Do you understand that, sir?
Yes, sir.
All right. Give me just a second here. Hold on. All right. Sir, have you received a copy of the 24/7 affidavit?
I just got the warrant for arrest served to me today when I turned myself in, but that's it.
All right, I'm going to share my screen so you'll see what the warrant was based on. Give me just a moment here.
I don't know why they put that there. Maybe that is
Sir, can you
Bobby.
see
We don't
that
know.
document now?
Yes, sir.
All right, I'll zoom in as much as I can. And this, just for the record, in both files is the affidavit on which the 24/7 warrant was issued. It is an affidavit from Seth Soderholm, who is a deputy at the Barnes County Jail, or a jail employee. He indicates that the defendant failed to make payments towards the alcohol monitoring system as required. He is 25 days behind. Balance is -152.
That's it.
You see that, sir?
Yes, sir.
All right. So I'm going to stop my screen share,
I pressed pause.
and I'm going to make sure you are
It's
aware
still
of your
running.
rights that apply in this
Nothing
matter.
listens to me. Lousy.
Arguably, this is a bail review in which the rules of evidence don't apply and the court simply reconsiders bail. It arguably is a contempt proceeding. It also arguably is a probation revocation proceeding in the 2023 matter. Because of that, sir, I'm going to read you the rights that are the most protective of you. Even though it might be a different set of rights that apply, I'm going to read you the contempt rights because those are the most protective of you, sir. So the primary purpose of remedial contempt is to impose a sanction conditioned upon performance or non-performance of an act required by court order or to induce compliance with a court order. The primary purpose of punitive contempt is to unconditionally punish contemptuous offenders and vindicate the court's authority. Contempt of court includes, among other things, intentional refusal to produce a record, document, or object after being ordered to do so, or intentional disobedience, resistance, or obstruction of court's authority, process, or order, or the intentional non-payment of money ordered to be paid when execution is not possible. In a contempt proceeding, the court must first determine whether remedial or punitive contempt proceedings are appropriate. Here, the court finds remedial contempt procedures are appropriate. Remedial contempt sanctions include one or more of the following. The court can order compensatory reimbursement of money, including costs, expenses, and attorney's fees, directly related to a loss or injury suffered by the contempt, not to the court. The court can order that you be incarcerated for up to 6 months or for as long as the contempt continues, whichever is less. The court can order a $2,000 per day forfeiture until the contempt ends. The court can enter an order designed to ensure compliance with the court's previous order, or the court can impose any sanction the court finds appropriate if the previously discussed sanctions would be ineffectual to stop continuing contempt. You have the right to be personally present in court. You have the right to reasonable notice of any allegations against you in an order to show cause. You have the right to reasonable bail. You have the right to attorney representation and consultation. In a contempt proceeding, you have the right to privately retain counsel. You have the right to represent yourself. If jail is a potential consequence, you have the right to a public defender. Here, because both of these matters are criminal matters and jail is a potential consequence, you always have the right to a public defender in these cases at every stage of the proceedings, including this one. You have the right to reasonable delays to prepare for an evidentiary hearing. You have the right to an evidentiary hearing and an opportunity to be heard at that evidentiary hearing. The standard of proof in a remedial contempt case is clear and convincing evidence, and that burden rests with the state to establish by clear and convincing evidence that you willfully, intentionally, inexcusably, and unjustifiably committed contempt. You, as the defendant, bear the burden to establish any defenses, for instance, justification or impossibility. The rules of evidence apply Again, this is one of the points where it differs depending on how the court views the hearing. But in contempt proceedings, the rules of evidence apply except for summary contempt. The rules of evidence don't typically apply in a bail review, nor do they typically apply in a probation revocation proceeding. You have the right to confront and cross-examine witnesses against you. You have the right to testify or to remain silent, to present evidence and call witnesses on your behalf, and to use the court's subpoena power to force those witnesses to appear. Sir, do you understand your rights?
Yes.
All right. So with respect to the allegation in both files that you are behind on your payments, approximately $150 or 25 days worth, and as a result, you are in non-compliance with the rules for the 24/7 testing program. Do you admit or deny that allegation, sir?
I am behind on payments, yes.
Has anyone threatened you, forced you, or coerced or made any promises to you in order to get you to waive your right to have a contested hearing and admit to this matter?
Nope.
Is there any reason why I should not find you in contempt? Why are you behind on your payments, sir?
Just money is tight right now. All the stuff I'm doing, all the other stuff I got going on with Rhonda, meeting with her, eval, treatment, all that stuff, everything. Just money's tight. I didn't know it was 152 bucks either. On the screen out here it says like 300, so I was trying to get that all gathered up to pay all in one lump sum. I didn't know it was only 152.
Well, it was 152 when that affidavit was signed. And so I don't know if that has changed. But you understand that you're behind to a certain amount that resulted in the state seeking to bring you back before the court.
Correct.
Ms. Duffy, your thoughts?
In this case, Your Honor, Ms. Zimbrick, the clerk, pointed out to me when we were starting court that this 2023 file has been closed. The bail order that's in the 2025 case has both cases listed on it, and I think that's why the state filed it into both cases, because the affidavit had both, and it was presumably on the same bail order that they were reading from. So I think for clarification, we are just looking at the DUS case, not the DUI one, because he would have been resentenced in early December for that revocation, and I don't think the bond would apply anymore in that one. So just turning to the DUS case.
Well, I'm going to stop you just for a second here. And I looked at that as well. The reason that I proceeded the way I did is the resentencing ordered him to participate in the 24/7 program post-judgment.
Okay.
As a condition of probation. That's why I said I'm not clear whether this is a probation revocation proceeding, a bond review issue, or a contempt proceeding. And so to make that clear, the resentencing in file ending 378 included as a condition on page 1 of the judgment that was entered on December 1, 2025, Appendix A through 4/4/2026, and then 24/7 program, same probation conditions as originally imposed in Appendix A, with CD requirements. So I was under the impression that in that file, this was treated essentially as extending all of the requirements that were originally imposed as probation conditions, including the 24/7 probation condition. If I'm wrong, let me know, but that's why I proceeded the way I did.
Okay, understood. That clarification is helpful. I was looking through the judgment. It reads a little different on Odyssey than it does on the actual judgment. So that was, anyway, the clarification is helpful. In relation to his payments and being behind, the jail had reached out to me prior to filing an affidavit, and I told them to try to work with him, see if they could get Mr. Ashline to come up with some more money. Part of his requirements for 24/7 include paying for it. So I think at this point, the 24/7 program ties directly to community safety. He was resentenced on a third DUI within 7, so there is certainly a community safety risk here if he is operating a motor vehicle and not in a sober state of mind. The driving under suspension case, again, kind of ties directly in. So with that, it looks like I think he posted $750. I believe that's under both cases, or it applies to both cases. So I would ask the court to modify bond and set it in the amount of $1,000 cash or $5,000 surety. And then the same conditions as before, that he comply with 24/7, which includes paying for it. If he's unable to pay for it, he's going to need to figure that out. I understand it's not an ideal time of year to have extra money. Presumably most people don't, but I think that it ties directly to community safety, and it's an important part of the bail order. So I would ask the court to modify bond just slightly, increase it a bit, add a surety portion in the amount of $5,000, and then all the other conditions that were previously imposed to remain the same.
Ms. Chisholm, your thoughts?
Thank you, Your Honor. This is a difficult situation because obviously my client is in jail because he lacked the ability to pay for the 24/7 program. And so the argument remains the same. He has no financial ability to pay. And so we're asking the court to take that into consideration with respect to setting bail. He can't work and generate income to pay for these things if he's incarcerated, unfortunately, Your Honor. And so it's a double-edged sword here. I don't believe that he has any additional funds to pay should the court increase his bail. And so we're asking the court to consider keeping it as is and allowing him to be released to get back to work. And hopefully he can scrape some money together from friends, family, or somewhere to pay for this, Your Honor.
Mr. Ashline, is there anything that you want to tell me before I make a decision here?
No, just like I said before, money's really tight. I'm doing everything I can to make money so I can pay for all these things, but it just, that time of the year, everybody wants, $10,000 worth of work done and only pay a guy $500 to do it. So it's tough right now to make money, but that's all I got.
Ms. Duffy, I know this issue came before the legislature last session, and I'm fairly confident, my recollection is that the Cass County Sheriff was complaining about Judge Clark waiving these fees and ordering the county to simply absorb the fees in cases where the court found the defendant incapable of paying the fee. Ultimately, Sheriff Johnner tried to get the legislature to include a provision in the law saying that those program fees were non-waivable, and my recollection is that failed. Do you have any position on whether or not these fees are waivable? The situation that we're in here is Mr. Ashline hasn't been able to afford to pay these fees. The program is mandatory. The fees, I'm not certain that they are. And if they are, I don't know how that could be constitutional because we don't have debtors' prisons, and that's what it effectively would become if we were imposing a requirement without an ability to waive even a nominal fee. What are your thoughts on whether the court has that authority? Do you have any arguments?
Well, I understand the theory of debtor's prison. I understand that he's sitting in jail on a monetary purpose. However, that purpose is also tied to a bail order that is connected to community safely directly based on his priors. So related to waiving them, I don't know that if the legislature had wanted to make those waivable, I think they would have done that last session. They didn't do that. I don't recall that passing. So my recollection on that is the same as the courts. I didn't look it up right now, but related to it being a debtor's prison, I don't know that it's necessarily exactly that, because again, he is tied on a bail order that relates directly to community safety. So I think that monetary things that require the defendant to put together money, if it's tied directly to community safety and his ability to come to court, which in this case it is, I don't think that those things are unconstitutional. It's like the court often says, bail is meant to be reasonable, not necessarily affordable. And I think that this kind of ties into that as well. But related to anything further than that, that's all I have, Your Honor.
Ms. Chisholm, your thoughts?
I would agree. I do know that did not pass. And I do think that the court has the ability to waive those 24/7 fees based on a finding of financial hardship, is my understanding.
In my recollection was that Sheriff Johnner was trying to stop Judge Clark from waiving those fees, and that is what failed. Not that there was an effort to include it in the statute that those fees would become waivable. There are some jurisdictions, Washington, for instance, that expressly prohibit waiving 24/7 fees. North Dakota doesn't fall within that statutory purview. So I'm gonna take just a moment here.
You guys think like exactly like I think. This isn't like a court fee. This is his monitoring because of his third DUI. And probation is an alternative to jail. If you can't do the alternative, then you got to do the jail.
So I'm looking at Title 54, Chapter 12. Section 27 is the general program requirement. 27.1 is the partial suspension for treatment court program participants. 28 deals with program guidelines and fees and records. And there it says those with the program guidelines and program fees and records can be established there's a program fund. The program fees, it just says that an agency can collect program fees. The agency shall pay all program fees into the general fund. Section 31 just allows it to be included as a condition of bond. Now, if I go to the administrative code, give me a minute with that.
Excellent job. Excellent job, Kay.
Title 1259 allows the 24/7 program to be used as parole. It can be used as a condition of probation.
He has a job. He works every day. He wants out so he can go back to work. Linus, it's too soon. Okay? It's too soon. Let's all order pizza for dinner tonight to help lean us through this hard time. It's called solidarity.
Well, effective August 1, 2025, the legislature has added the court may not waive those fees language. So I can't waive it, it looks like. Again, I don't know how that becomes constitutional. That being said, the constitutional challenge hasn't been raised.
Just a second. Where did you read that, Your Honor?
Subsection 7. 390801 sub 7 is used in this title. 24/7 means the program under chapter 5412. The offender is responsible for all 24/7 program fees, and the court may not waive those fees.
Hey, I'm streaming tonight. I can't pause it, so I gotta hurry. I'm streaming tonight. Let's do pizza during my stream. Let's do this. Truthfully, I would have eaten the burnt pizza and been happy. I would have.
So apparently the legislature is limiting my ability to waive those fees in 24/7, at least post-judgment. So that would apply to file 378. But if I can't waive them in 378, that effectively means I can't waive it in file 283 either. Here's what I'm going to do. I'm going to find the defendant is not in contempt of court. I find his indigent status means that it is not possible for him to pay those program fees, and therefore he is not intentionally, willfully, and inexcusably engaged in contemptuous behavior. So I'm not going to hold that he is in contempt of court. I'm going to release Mr. Ashline with 1 day credit for time spent in custody on the same bond orders that were previously imposed. Bail will remain the same. I was considering in the alternative reducing his bail to an amount sufficient that the bail could be applied against the 24/7 fees. I'm not going to do that either. I'm simply going to put him back on the program. I'm not going to hold him in jail when he is voluntarily appearing in court. He voluntarily surrendered himself on these warrants when he learned the warrants exist. He has appeared as required.
And beer.
The
Pizza
purpose
and
of
beer.
bail and all of Rule 46 is tied not just to community safety, but it is to the defendant's likelihood to appear in court. That is the presumption and the start point for the court, and all of the bond conditions that the court imposes have to be tied to ensuring the defendant appears when required. Community safety is one factor the court can consider, but there again, this was a mandatory condition imposed as a condition of the court's judgment. It was imposed on the new file, the driving under suspension, only because it was a mandatory condition in the old file. So that's where I'm at. I'm simply releasing Mr. Ashline. Mr. Ashline, I want to make sure we confirm your address. Can you tell me where we can send you mail?
507 7th Street Northeast, Valley City, North Dakota.
All right. Is that your address, sir, or is that someone else's address?
My parents' address.
And what is your parents' name so we can make sure that it says care of?
Susan and Terry Ashline.
Susan and was it Carrie?
Terry with a T.
With a T, as in Terry.
Correct.
All right. So we'll make sure that that gets noted. And then again, I'm simply reinstating bail, releasing the defendant on the same bond order that was entered November 3, 2025. That's what I'm going to do. So you're still required to participate in the 24/7 program. You need to make things square with the sheriff on the payment issues, but I'm not going to hold you in jail. I think that's counterproductive, as your attorney argued, to hold you in jail when you're voluntarily appearing when you're supposed to. Make sure you're following that bond order, including the requirement that you not drive without license or privilege to do so. And we'll go from there. Any questions, Ms. Duffy?
No questions, just for clarification, while the court was I think researching, I was doing the same for future cases. The way I'm reading it, the 24/7 programs are established by the Attorney General, who has a set of guidelines. Within his guidelines, the Attorney General does talk about how the court can find a finding of hardship pre-sentence. So I think for future cases, that's something to certainly keep in mind. It looks like the court's able to waive those fees as long as it's pre-judgment, not post, and as long as it's not tied to their 24/7 restricted license. It sounds like the court can waive those.
Well, pre-sentence, I can always delete the condition. Post-sentence, I can't. So
No,
that makes sense to me.
You could keep the condition if the court felt it was appropriate as well. It's just you wouldn't have to have the fees because that's within the Attorney General's guidelines on page 4, towards the bottom. If you and Ms. Chisholm were interested in reading it, that's where I found it, just for future reference, not necessarily today in this case, but in the future, it's, I think, an important thing to keep in mind too.
I appreciate that. Thank you.
Otherwise, nothing further from me. Thanks.
All right. Ms. Chisholm, anything else?
No, Your Honor, thank you.
All right. We are adjourned. Have a good day.
Thank you. You too.
Okay.
All right.
No.
Orange County District Court is now in session.
I
This
can't
December
stop it.
22, 2025. The time is now 1 p.m.
I can cut it off though. I can completely cut it off. All right. I can't pause the clips because my software won't let me right now. Everybody's having drama issues this morning. It's fine. We're moving to another docket. And this isn't about any of the cases in this docket. This docket stressed me out. It made me feel stress watching it because it's so chaotic. It's just nothing but chaos. And the judge, I think he's a little strict. It's just too much chaos for me to know completely. But you'll see what I mean. Oh. There.
Good morning, Miss Terry.
Good morning. Yes, sir. You have, let's see, Brandy Castillo set this morning. You ready to
Yes,
speak to
ma'am.
her or you need to talk to the state?
No, I'm ready to speak to her.
Okay, got it. I'm going to move you to room 1. Here we go.
Thank you.
Yes, sir.
Terry,
Yes, ma'am.
hi. I was
Morning.
just wondering if I had a question about the bond dockets.
Okay,
Are
go ahead.
those so on mine that I received, it doesn't have the folks that were refused on that docket. I don't know if I was just sent the wrong one or if they're just
No.
not going to be included
They're
at
not going to
all.
be included. They're not going to be included. We're only doing the ones that are being presented now, so
Okay.
anything refused, if they bonded out, none of that is on the dockets anymore.
Okay, I just want to make sure because I still have to complete paperwork for that. So for the people
The
that like
refusals?
refusals, yeah, I'll just let my leads know because they usually they reference my actual docket. So if
Okay,
I
yeah.
have extra folks, then I'll just let them know.
Yeah, just let them know the refusals are no longer on the docket.
Okay.
They're only putting people who we are presenting. So that's something new,
Right.
but you'll have to get with pretrial on that to see
Right.
what's going on.
Okay, sounds
Same
good. Thank
thing.
you.
Thank you. Abe, I have Cheatham here, all right? Tell me when you're
Okay.
ready to be put in a room.
I just got the discovery from it, yeah.
Is your other case a probation case by chance?
No,
Oh, thank God.
just, I don't see it in there. Just tell me what are they?
Thank you.
I know he's done everything except he owes money, right? Well, am I going to go into the room right now?
On the docket, it says that it belongs to Finch. That's
Yeah,
who I
no.
sent it to.
No, I just got
Oh,
it
it
from
belongs to Abe Garza and Finch.
Okay,
Finch not
what's
making-
your email, Abe, and I'll forward it to you.
A Garza Law,
A Garza, oops, law.
Law,
It popped up 305.
yes.
Okay, all right, it's on your way. It's on the way now.
But I know he's done everything, right? Except Teal's money.
Except for monies, and he disappeared. They're recommending if he pays in full term on SAP, but
He
I mean,
can't afford it.
yeah, we know we can't do that. So whatever you want to work out.
Okay, yeah.
Okay, sounds good.
You want to confer with the state real quick before your
Yeah.
client? Okay.
Yeah, sure, if she's here.
Yeah, she's here. I'm going to move you to room 6. There
All
you
right,
go.
is she here?
Taylor, room 6. There
Is she
you
here?
go. Yes,
All
room
right.
6. Let's see. Good morning, Mr. Arguelles.
Good morning, Terry.
Garrett Belk, got 2 cases.
Yes,
You
ma'am.
ready on those?
I am, and I can confer with him just to get him to go over paperwork.
Okay, you just need to talk to him. So you do have an offer, correct?
Yes, ma'am.
Let me find him. Hold on just a moment.
Thank you.
Is she looking for the judge? I think she is. Terry, quit calling me. I'm in the middle of a live stream. She has one of those cameras that follow you around. It gets more stressful. She stresses me out too, and the judge.
Mr. Arguelles, your client is on the 7th floor or something like that, or annex or something. So he's coming in on another camera. So just give me a moment.
Yes, ma'am. Thank you.
All right, Mr. Arguelles, I am moving you to room 5, Mr. Arguelles, with your client.
Where's Alex? Terry, where's Alex?
Valverde, she's
Yeah,
here.
I'm right here.
We're just gonna terminate it on SAT.
Okay, I'll do all that in a little bit. The withdrawal.
It's
Okay, we don't have to go in
possible
front of the judge, right? You
I
just turn it on
accidentally
SAT.
recorded
Yeah,
on
you're gonna let the kid
1.25,
know
but I don't
because I'm
know.
not gonna talk to him.
No, I'll talk to him.
Okay, thank you. And he can get a copy of it from his officer. Sorry, I'm busy doing
No,
stuff.
that's fine. It's not a big deal.
Okay, thank you.
Right, Abe, moving you to room 3 for your client, your other client.
Thank you.
Where are you, Abe? Good morning, Mr. Hunt.
Good morning.
Let's see, Alexander Moros,
Yes,
you got an offer, you ready on that one?
James
ready.
Hunt, guys.
Okay, give me just a moment.
James,
thanks.
not Mike.
Let's see, Mr. Hunt, moving you to room 2.
Thank you.
Yes, sir. We've got CLO Flores here.
Hey, Rob.
Hello, how you doing?
Good. I'll let you take over then. They're gonna withdraw, and that way I can get out and finish other stuff that wasn't done. They're gonna on Tenorio, they're gonna withdraw and terminate unsat.
Okay, that's why we're watching it. It stressed me out watching this docket. It's just stressed me out.
Did you hear me?
Yeah. Yes, I thought are you here? Can you hear me?
Yeah, I can hear you. Now I
Okay.
can.
All right.
Terry,
Go ahead, Abe.
she said they can't find the paperwork, and I could have sworn I did it this weekend.
On Cheatham?
Yeah.
Okay, you're gonna have to look for Deborah Gussman's name because I didn't do the paperwork on that one. Look for Gussman.
No, that's a regular. It's Deborah Gus. Okay, I'll tell them to look for Deborah. Thanks.
Yeah, look for Gussman. Yeah.
Oh.
Under your email. If they didn't get it, it should be under your email.
Okay. All
Or
right.
type in Cheatham or something like that.
Okay, I'll tell them.
All righty.
Thank you.
Hi, yes, sir. Ms. Vilma?
Good morning.
Good morning. Let's see. You have Jeff Washington set this morning on an MTR. You got an offer on that one?
Yes, I do.
Okay, got it. All the breakout room. I think Washington is not here yet, and I have all the breakout rooms full anyway. So just give me a moment. I have you on the waiting list here. Okay.
Right, thank you.
Thank you. And Patrick, you're just here for the bonds, right, Patrick? Okay. Just hang tight. Thank you. Thank you.
Can you send me in the CLO to a breakout room, Terry?
Sure. I'm gonna move you to room 4.
Okay.
And the other CLO, there it is, Mr. Floyd.
Thank
Room
you.
4. There you go. Yes, ma'am. Mr. Arguelles?
We're ready, Terry, whenever the court is. You already signed the paperwork.
Okay, we're going on both cases, Mr. Arguelles?
No, ma'am. We're going for the agreement under the 508.
A 508 is going to be a plea, and we're going to TIC the 509?
Correct.
Okay, got it. And Mr. Swerk, are you ready on Brandy Castillo?
Yes, ma'am, Ms. Terry.
Okay, got it. All right. Judge, whenever you're ready, we got 2 pleas ready. Just tell me which one you want to do first.
Have
them do Castillo first.
But Cas-
all units lowered are properly secure and verify on your panels that every door within your assigned area is secure as required.
She's muted, Terry.
They're going.
Guys, cause number 2025 CC 017018, State of Texas versus Brandy Castillo. Are you Brandy?
Yes, sir.
Castillo? Are you Brandy Castillo?
Yes, sir, I am.
All right, good morning. Raise your right hand, please. You swear to tell the truth. Right hand.
Oh, sorry, sir.
You swear to tell the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
All right, thank you. Ms. Castillo, is it okay with you that we proceed by video conference?
Yes, sir.
Thank you. You are charged with the offense of failure to ID with a fugitive warrant. That's a class. Ms. Castillo, I apologize. You're charged with failure to ID, not as a fugitive, because this is a Class B misdemeanor, which makes it punishment up to 180 days in Grant County Jail and up to a $2,000 fine. Do you understand?
Yeah.
Yes or no?
I said yes.
Yeah, you said yeah. Yes or no, okay?
Yes.
You have several constitutional rights. You have the right to remain silent. You also have a right to a jury trial and to confront the witnesses against you. And what that means is you could ask the state of Texas to bring their witnesses into open court to testify against you, where your lawyer can cross-examine those witnesses in front of a jury. During those proceedings, Ms. Castillo, your attorney can call as many witnesses as he would like for you or on your behalf in front of that same jury. Do you understand that you have those rights?
Yes, sir.
Do you also understand that you do not have to give up those rights?
Yes, sir.
All right, but if you want to give them up, you can. And you do it by filling out this paperwork that I shall share with you right now called the Defendant's Waiver of Constitutional Rights and Court Admonitions. Ms. Castillo, did you go over this paperwork with your lawyer before you signed it?
Yes, I did.
Do you understand what's in these documents?
Not really.
You don't understand?
No.
All right, let's see if I can clear it up. If not, you're going to have to go back and talk with your lawyer again. These documents tell me that you understand what you're charged with, you understand the range of punishment, and then you also understand you have all those trial rights that we just talked about, like to have a jury trial, confront the witnesses, all that stuff. But this paperwork tells me that you want to give up those rights or waive them because you want to get into an agreement with the state of Texas on this case. Is that what you want to do?
No, not really. I know what I'm talking about. I'm just tired. I need to go back to bed or something.
You don't want to get into this agreement?
No, I don't.
Okay, thank you.
Thank you. Ms. Terry, can you just send it back to the port of origin, please?
Yes, sir. Send it back. No agreement or set for trial? Mr. Swerk?
Here. Ma'am?
Mr. Swerk, send it no agreement or send it back set for trial?
You can send it for trial.
Okay.
Ter-
Thank you,
Terry,
sir. Yes, sir.
Can you send a reminder? I mean,
No, I'm gonna have to send you new paperwork because I didn't send you the paperwork to begin with, Abe, but I'm sending it now.
oh, okay.
I'll send it, I'm sending it now.
All right. Sorry.
It's regular plea paperwork and a voucher, correct?
Correct.
Okay, got it. I'm sending it to you now, Abe.
All right. Thank you.
Yes, sir.
I could have sworn I did it. Or maybe.
Okay. Okay, no worries, no worries. I'm sending it now. Let me just, yeah, it just takes me just a minute to do it. Let me get a approver. Let's see, and I did Antonio Cheatham. Yeah, yes. Okay.
Whenever
All
you
right,
two are ready, whenever you two are done fiddling around,
Okay.
can we play maybe?
Yes, sir. All right. Belka's next. Let me get Belka the camera.
He's on camera, but no. Belt's in another place, but he's muted.
He's muted. Okay.
Wait, is that Belt? I thought Belt was over here on the right.
No, Belt. Yeah, Belt, can you unmute yourself, Mr. Belt? Unmute yourself.
He's asking somebody, I think. Yeah.
Okay, there you go, Judge.
All right, wonderful.
Hello, Your Honor.
Hey, good morning. That's cause number 2025 CC 014508, State of Texas versus Mr. Garrett Belk. Are you Garrett Belk?
No, sir.
Wait a second. Not you. Hang on.
That's my case, Morose.
All right. Are you Garrett Belk?
Yes, Your Honor.
Thank you, sir. Good morning to you. Can you raise your right hand, please? You swear to tell the truth, the whole truth, nothing but the truth, so help you God.
Yes, Your Honor.
Thank you, Mr. Belk. Mr. Belk, is it all right with you that we proceed by video conference?
Yes, Your Honor.
Thank you, sir. You are charged with the offense of evading arrest or detention. That is a Class A misdemeanor, Mr. Belk, punishable by up to a $4,000 fine and up to 1 year in the Bear County Jail. Do you understand?
Yes, Your Honor.
Mr. Belk, you have several legal rights, sir. You have the right to remain silent. You also have a right to a jury trial and to confront the witnesses against you. Mr. Belk, what that means is you could ask the state of Texas to bring their witnesses into open court to testify against you, where your lawyer can cross-examine those witnesses in front of a jury. During those proceedings, Mr. Belk, your attorney can call as many witnesses as he would like for you or on your behalf in front of that same jury. Mr. Belk, do you understand, sir, that you have those rights?
Yes, Your Honor.
Do you also understand, Mr. Belk, that you do not have to give up those rights?
Yes, Your Honor.
But if you want to give them up, sir, you can, and you do it by filling out this paperwork called the Court's Admonishments and Defendants Waivers and Affidavit of Admonitions. Mr. Belk, did you go over this paperwork with your lawyer before you signed it?
Yes, Your Honor.
You understand what's in these documents?
Yes, Your Honor.
All right, great, because these documents tell me, sir, that you understand what you're charged with, you understand the range of punishment, and then you further understand you have all of those trial rights we just talked about. But you're telling me, Judge, I want to give up those rights or waive them because I want to get into an agreement with the state of Texas on this case.
Yes,
Is that what you want to do, Mr. Belk?
Yes, Your Honor.
All right, wonderful. Then I will approve your waivers and have them filed with papers in this cause. Mr. Belk, Keely, there is an agreement, right?
Yes, Your Honor.
All right, Mr. Belk, evidently you do have a plea bargain in this case. First thing you need to understand, sir, I don't have to go along with your agreement. However, if I don't, I will allow you to withdraw your plea and start all over again. So anything you say in the next few minutes will not be held against you. Do you understand, sir?
I do, Your Honor.
All right, Mr. Belk, do me a favor. Listen up. State of Texas is going to tell us what the plea bargain is. Let's make sure it is what you agreed to. Go ahead, State.
Yes, Your Honor. It is a $0 fine plus court cost, 79 days in the Bear County Jail, credit for time served, both time and money to run concurrent. And if it pleases the court, this will be a judgment satisfied.
Isn't there a TIC, Keely?
We're not TICing it, Your Honor. We are outright dismissing it, and I have submitted that for dismissal.
Okay, so that's not even part of the plea bargain.
No, Your Honor.
All right, wonderful. All right, Rolando, is that the agreement?
It is, Judge.
Mr. Belk, is that what you agreed to?
Yes, Your Honor.
All right. Rolando, your voucher says 0.0.
Correct, Your Honor. I'm retained in this case.
Oh, duh.
I'm retained.
Yeah, why do they even give you a voucher? I don't even understand that.
I think they just sent the paperwork all together.
Okay. All right, hang on a second. All right, Rolando, does Mr. Belk have a rational as well as factual understanding of the charge and the proceedings against him?
He does, Your Honor.
Has he been able to assist you in the preparation of any possible defenses?
He has, Judge.
In your opinion, is he legally competent to waive his rights to enter into this plea?
He is, Your Honor.
All right, Mr. Garrett Belk, are you a citizen of the United States of America?
Yes, Your Honor.
Please tell me how you plead to the Class A misdemeanor offense of evading arrest or detention. Guilty, not guilty, or no contest?
No contest, Your Honor.
Mr. Belk, you understand I can still find you guilty based upon that plea?
Yes, Your Honor.
Anybody force you, threaten you, put you in fear, or promise you anything to make you plead that way?
No, Your Honor.
You're doing so freely and voluntarily?
Yes, sir, Your Honor.
Thank you, Mr. Belk. I will accept that plea. Upon that plea, I find you guilty of evading arrest or detention, a Class A misdemeanor. I assess punishment at 0 fine, the cost of court, 79 days in the Bear County Jail. Cost of court and the time will run concurrent. I will give you credit for time served, which means, Mr. Belk, your judgment is satisfied by the time you've already served. Mr. Belk, this was a plea bargain. You do not have a right to appeal. Mr. Belk, you got any questions?
No, sir, I don't, Your Honor.
You take care of yourself. Stay well. Merry Christmas.
Merry Christmas, Your Honor. Thank you.
Appreciate it. Thanks, Rolando.
Thank you, Judge. Thank you.
Thank you, Rolando.
Thank you, Mr. Belk.
Quick question, Miss Taylor.
Yes.
For that dismissal, was that going to be submitted via County Court 8, or where am I expecting that?
You should be getting it. I submitted it to Adobe Sign a few minutes ago.
Okay, I just wanted to know. Thank you.
You're welcome.
Yeah. In other words, Keely, she's saying, Judge, you need to sign that right now. You know, give me just
No,
1 second,
Judge.
Jordan.
I'm
My
not.
goodness.
I'm not trying to rush you. I'm not trying to rush you. I'm just making sure.
No,
I want to
she's
make
got-
sure I got all my ducks in a row. I don't want to leave anybody in jail.
Understood. This young prosecutor doesn't miss a thing, man. That dismissal's there before the case is even dismissed. I'm telling you.
Sure is. I don't doubt it for a
Let me
second.
sign it.
I don't doubt it.
Hey, Jordan.
Yes.
By any chance, do you show Mr. Belk as a blue warrant?
Let me look really quick. Let me
Thank you.
pull up the case.
I don't know what a blue warrant is.
Just sign it, Jordan.
Thank you, Judge.
Mhm.
1 second, Rolando. I'm checking. It's loading.
Thank you, Jordan.
Mhm. So I don't see any other warrants. These are the only 2 active cases that I can see.
So once everything's submitted, he should be getting out of the jail.
Yes.
Okay.
Yeah.
Did you hear that, Mr. Belk?
Yes, sir, I did. Thank you, Rolando.
Okay. Thank you, Jordan. Thank you, Mr. Belk.
Yes, sir.
Yeah, thank you.
Have a good day. Merry Christmas.
Merry Christmas.
All right, we're ready on Moros? Moros.
Mr. Hunt, you ready, Mr. Hunt?
Ready.
Okay.
Cause number 2025 CC 016728, State of Texas versus Alexander Moroz. Are you Alexander Moroz?
Yes, sir. Yes, Your Honor.
Good morning, sir. Could you raise your right hand, please? You swear to tell the truth, the whole truth, nothing but the truth, so help you God.
Help me, God.
All right, thank you, Mr. Moroz. You can lower your
Yes,
hand.
sir.
Mr. Moroz, is it all right with you that we proceed by video conference?
Yes, sir. Yes, Your
Thank you,
Honor.
sir. You are charged with the offense of evading arrest or detention. Mr. Moroz, that's a Class A misdemeanor, so it's punishable by up to a $4,000 fine and up to 1 year in the Bexar County Jail. Do you understand, sir?
Yes, Your Honor.
All right, Mr. Moroz, you have several legal rights, sir. You have the right to remain silent. You have a right to a jury trial and to confront the witnesses against you in this case. Mr. Moroz, what that means is you could ask the state of Texas to bring their witnesses into open court to testify against you, where your lawyer can cross-examine those witnesses in front of a jury. During those proceedings, Mr. Moroz, your lawyer can call as many witnesses as he would like for you or on your behalf in front of that same jury. Mr. Moroz, do you understand, sir, that you have those rights?
Yes, Your Honor.
You also understand, Mr. Moroz, that you do not have to give up those rights.
Yes, sir.
All right, but if you want to give them up, you can. And you do it by filling out this paperwork for me called the Defendant's Waiver of Constitutional Rights and Court Admonitions. Mr. Moroz, did you go over this paperwork with your lawyer before you signed it?
I did.
You understand what's in these documents?
Yes, Your Honor.
All right, great. Because these documents tell me that you understand what you're charged with, you understand the range of punishment, and then you further understand you have all of those trial rights we just talked about, but you're telling me you want to give up those rights or waive them because you want to get into an agreement with the state of Texas on this case. Mr. Moroz, is that what you want to do?
Yes, sir.
All right, then I will approve your waivers and have them filed with papers in this cause. Mr. Moroz, evidently you have a plea bargain in this case. First thing you need to understand, I don't have to go along with your agreement. However, if I don't, I will allow you to withdraw your plea and start all over again. So anything you say in the next few minutes will not be held against you if that happens. Do you understand?
Yes, sir.
All right, Mr. Moroz, please listen up. The state's going to tell us what the plea bargain is. Let's make sure it is what you agreed to. Go ahead, state.
Yes, Your Honor, it is a $0 fine plus court costs, 39 days in the Bexar County Jail, credit for time served, both time and money to run concurrent, and if it pleases the court, this will be a judgment satisfied.
All right, James, is that the agreement?
Yes, Your Honor.
Mr. Moroz, is that what you agreed to?
Yes, Your Honor.
All right, James, does Mr. Moroz have a rational as well as factual understanding of the charge and the proceedings against him?
He does.
Has he been able to assist you in the preparation of any possible defenses?
Yes, Your Honor.
In your opinion, is he legally competent to waive his rights and enter into this plea?
Yes, Your Honor.
All right, Mr. Alexander Moroz, are you a citizen of the United States of America?
Yes, Your Honor.
All right, please tell me how you pleaded the Class A misdemeanor offense of evading arrest or detention. Guilty, not guilty, or no contest?
No contest.
You understand, Mr. Moroz, I can still find you guilty based upon that plea.
Yes, yes, sir.
Anybody force you, threaten you, put you in fear, or promise you anything to make you do that, sir?
No.
You're pleading freely and voluntarily.
Yes, sir.
Thank you, sir. I will accept your plea of no contest. Upon that plea, I would find you guilty of evading arrest or detention, a Class A misdemeanor. I assess punishment at 0 fine, cost of court 39 days in the Bexar County Jail. Cost of court and the time will run concurrent. I will give you credit for time served, Mr. Moroz, which means your judgment is satisfied by the time you've already served. Mr. Moroz, this was a plea bargain. You do not have a right to appeal. Mr. Moroz, you have any questions?
No, sir.
All right, you take care of yourself. Stay well. Good luck, all right?
All right. Merry Christmas. Take care.
Merry
Thank you so
Christmas
much.
to you. I appreciate it.
Bye. Take care.
Thanks, Judge.
Bye, James.
We'll see you.
Go back to attorneys conferring, Judge, so.
Is Alex there?
Valverde? No, Judge,
Yeah.
she took off.
I got a
We
piece of paperwork called withdrawal, but when I open
Okay.
it says this agreement has already been canceled. I can't sign it.
Sorry, Your Honor, that's me. I'm the CLO covering for Alex, Robert Flores. I prematurely sent that paperwork.
Oh, okay. So you'll follow up. Okay, yeah, because it says it's already been canceled, so I can't sign it. I'll just get rid of it.
And I'm sending the correct. I sent it without the signature boxes correctly placed, and I'm sending the correct one out.
Yeah, let me. I
Let's
just
go,
came
let's
up
go,
with
let's go. There's no one there.
All right, Judge Abe, you ready on Cheatham?
Yeah, I am. And on Tenorio, that's just gonna be they're just gonna close it out, term on set.
Okay, term on, they would do an MTR and term on sat on Tenorio. Thank you.
Right. They're just gonna term it on set. I don't remember if we did a voucher on it or not.
You want me to send you a plain voucher, Abe?
You can do it. You can do it
Okay.
for free. You got enough money. You can do it for free.
I'll send.
Look at he bought all those books behind him. Look at that. He must have some money. Paperwork's coming up slow, Terry. Let's get this. See if we can get it going before it all crashes and burns. It's 2020. It's just slow. 2025 CC 017517. State of Texas versus Antonio Cheatham. Are you Antonio Cheatham?
Yes.
All right. Good morning, sir. Can you raise your right hand? You swear to tell the truth, the whole truth, nothing but the truth, so help you God.
Yes.
Thank you, Mr. Cheatham. You can lower your hand, sir. All right, Mr. Cheatham, let's see. Is it okay with you that we proceed by video conference?
Yes.
All right, you are charged with the offense of forgery in order to obtain property or service from 100 to 750. That is evidently a Class A misdemeanor, so it's punishable
Class B, sir.
by up to a $4,000 fine. Yeah,
It's a
up to a
Class B.
$4,000 fine. Up to, oh, it says Class A on the
No, it should be a Class B, Judge.
docket sheet. Keely, what is it?
It shows a Class A on my end, Your Honor, but let me double check.
Yeah, it says Class A on the docket sheet.
Okay.
Hang on, let's figure it out. I've never heard of it, so.
I hope the forger goes to jail. I'm not going to lie.
Officer Riley, 6439. Officer Riley, 6439.
The judge
I read it as a Class B.
breaks up because he
Where?
breaks the internet.
Well, let me see.
I mean, you got the penal code in front of you or what?
I was looking at it. I mean,
It clearly says,
all right.
look on the docket sheet. It
I
says MA.
apologize. It's Class A.
It's an A. All right, Mr. Cheatham. That forgery in order to obtain property or service 100 to 750 is a Class A misdemeanor, Mr. Cheatham. So the range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. Do you understand, sir?
Yes.
All right, Mr. Cheatham, you have several legal rights, sir. You have the right to remain silent. You have a right to a jury trial and to confront the witnesses against you in this case. What that means, sir, is you could ask the state of Texas to bring their witnesses into open court to testify against you, where your lawyer can cross-examine those witnesses in front of a jury. During those proceedings, Mr. Cheatham, your attorney could call as many witnesses as he would like for you or on your behalf in front of that same jury. Mr. Cheatham, do you understand, sir, that you have those rights?
Yes.
You also understand, sir, that you do not have to give up those rights.
Yes.
All right, but if you want to give them up, sir, you can, and you do it by filling out this paperwork called the Defendant's Waiver of Constitutional Rights and Court Admonitions. Mr. Cheatham, did you go over this paperwork with your lawyer before you signed it?
Yes.
You understand what's in these documents?
Yes.
Wonderful, because these documents tell me, sir, that you understand what you're charged with, you understand the range of punishment, and then you further understand you have all of those trial rights that we're just talking about. But you're telling me that you want to give up those rights or waive them so you can get into an agreement with the state of Texas on this case. Mr. Cheatham, is that what you want to do, sir?
Yes.
Thank you, sir. Then I will approve your waivers and have them filed with papers in this cause. Mr. Cheatham, evidently you have a plea bargain in this case. First thing you need to understand, sir, I don't have to go along with your agreement. However, if I don't, I will allow you to withdraw your plea and start all over. So anything you say in the next few minutes will not be held against you. Do you understand, sir?
Yes.
Mr. Cheatham, please listen up. The state's going to tell us what the plea bargain is. Let's make sure it sounds familiar to you. Go ahead, state.
It is a $0 fine plus court costs, 99 days in the Bexar County Jail, credit for time served, both time and money to run concurrent. And if it pleases the court, this will be a judgment satisfied.
Abe Garza, is that the agreement?
That is our understanding of the agreement, Your Honor.
Mr. Cheatham, is that the agreement, sir?
Yes.
All right, Abe. Does Mr. Cheatham have a rational as well as factual understanding of the charge and the proceedings against him?
Yes, Your Honor.
Has he been able to assist you in the preparation of any possible defenses?
He has.
In your opinion, is he legally competent to waive his
Yes.
rights and enter into this plea?
Yes, Your Honor.
All right, Mr. Antonio L. Cheatham, are you a citizen of the United States of America?
Yes.
Please tell me, Mr. Cheatham, how you plead to the Class A misdemeanor offense of forgery in order to obtain property in the amount of $100 to $750. Guilty, not guilty, or no contest?
No contest.
You understand? I can still find you guilty, Mr. Cheatham.
Yes.
Anybody force you, threaten you, put you in fear, promise you anything, make you plead that way?
No.
Doing so freely and voluntarily.
Yes.
Thank you, Mr. Cheatham. I'll accept your plea of no contest. Upon that plea, I find you guilty of forgery in order to obtain property in a value of 100 to 750. Class A misdemeanor. I says punishment at zero. Fine. The cost of court 99 days in the Bexar County Jail. Cost of court and time will run current. I will give you credit for time served, Mr. Cheatham, which means your judgment is satisfied by the time you've already served. Mr. Cheatham, this was a plea bargain. You do not have a right to appeal. Mr. Cheatham, any questions?
No.
All right. You take care of yourself. Stay well. Merry Christmas.
All right. Merry Christmas. Thank you.
Same to you, Abe.
You too. Take it easy, Jed.
All right,
Terry,
brother.
can I talk
Yes,
to the
sir.
priest?
Oh, then, yeah, let me see.
Just to tell them what's going to happen.
Abe, I'm moving you to room 2, Abe.
Thank you.
All right. Good morning, Mr. Vale. You have Eric Delgado set this morning with 3 cases. You ready on that one?
I've done paperwork. I need to review it with him. Then I just need to visit with the prosecutor very briefly just to make sure I got the alpha down right.
Got it. Keely, move yourself back to 6, Mr. Vale. I'm moving you to 6. There you
Okay,
go.
thank you.
Everybody breathe. Everybody breathe. Breathe for a minute. She's muted and we can still hear her.
Thank you.
Oh, okay. Let me, okay.
All right, this is clause number County Court Case 666-141, State of Texas versus Jeff Washington. Are you Jeff Washington?
Yes, Your Honor.
All right, good morning, sir. Could you raise your right hand, please? You swear to tell the truth, the whole truth, nothing but the truth, so help you God.
Yes.
Thank you, Mr. Washington. You can lower your head. Mr. Washington, is it all right with you that we proceed by video conference?
Yes, sir.
Thank you. Let's see, Mr. Washington. It looks like you were placed on, hang on just a second, sir. You were placed on, what is this? Oh, here it is. Regular probation for the offense of assault, bodily injury for a period of 2 years on the 30th of December, 2022. Correct, sir?
Correct.
All right, state's filed a motion to revoke that community supervision. You are aware of that, right?
Yes, sir.
All right, Mr. Washington, they're going to read an allegation to you. Listen up, and then I'm going to ask you if it's true or not true. Go ahead, state.
We are proceeding on violated condition number 19, Your Honor. On or about the 20th day of November 2025 in Bexar County, Texas, the defendant, Jeffrey L. Washington, did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department, Substance Abuse Treatment Facility, Continuum of Care, in that the defendant failed to complete the aftercare program in violation of condition number 19.
Mr. Washington, do you understand that allegation, sir?
Yes, sir.
Is it true or not true?
True.
Thank you, sir. State, what are you going to do with the rest of them?
We are moving to waive and abandon the remaining violations, Your Honor.
All right, Mr. Washington, are you aware, sir, that based upon that one plea of true, I could, if I thought it was appropriate, revoke your community supervision in this case?
Yes, sir.
Mr. Washington, has anybody forced you, threatened you, put you in fear, or promised you anything to make you plead true?
No, sir.
Doing so freely and voluntarily?
No, sir.
Yes, sir, right? Freely and voluntarily, nobody's forcing you?
Yes, sir.
Okay, I will accept your plea of true. Is there an agreement?
Yes, Your Honor. It is a $0 fine plus court. Oh, sorry. Did you want me to tell you the agreement now or wait?
Yeah, but are we granting the motion or what are we doing?
Yes, Your Honor. We are asking you to, we are moving to, sorry.
Grant the
It's been
motion
a while since I've done one of these now. Grant the motion to revoke the defendant's community supervision and sentence them to a $0 fine plus court costs, 15 days in the Bexar County Jail, credit for time served, both time and money to run concurrent. And if it pleases the court, this will be a judgment satisfied.
All right, Ms. Bielma, is that the agreement?
Yes, Your Honor, it is.
Mr. Washington, is that what you agreed to, sir?
Yes, sir.
All right, then, sir, I'm going to find it is true that you violated condition number 19 of your community supervision. At this time, I grant the state's motion to revoke. I revoke your community supervision, sentence you to 0 fine, the cost of court 15 days in the Bexar County Jail. Cost of court and the time will run concurrent. I will give you credit for time served, Mr. Washington, which means your judgment is satisfied by the time you've already served. Mr. Washington, this was a revocation of probation. You have limited rights to appeal, which your lawyer could further advise you about. Mr. Washington, do you have any questions for me, sir?
No, sir.
All right, you take care of yourself. Stay well. Merry Christmas.
Same to you, Your Honor. Thank you.
I appreciate it.
Thank you, Judge.
You're welcome.
Okay.
That's Mr. Vale's client, Judge. He's confirmed with his other client right now, getting paperwork signed. So we'll be done with that one in a minute.
All right, Mr. Delgado, just hang on. Your lawyers will be back in a moment, all right?
Thank you, Your Honor.
You're welcome, sir.
Yo, she's lucky she didn't get thrown in jail right there.
Ray, you ready?
Yes, sir.
All right. Cause number 2024 CC 735-929, State of Texas versus Eric Anthony Delgado. Are you Eric Delgado?
Yes, Your Honor.
All right, good morning, sir. Can you raise your right hand, please? You swear to tell the truth, the whole truth, nothing but the truth, so help you God.
Yes, Your Honor.
Thank you, Mr. Delgado. You can lower your hand, sir. Mr. Delgado, is it okay with you that we proceed by video conference?
Yes, Your Honor.
Thank you, sir. You are charged in this case with the offense of theft of property, 100 to 750. Mr. Delgado, that is a Class B misdemeanor, so the range of punishment is up to a $2,000 fine and up to 180 days in the Bexar County Jail. Do you understand, sir?
Yes, Your Honor.
All right, Mr. Delgado, you have several legal rights. You have the right to remain silent, and you have a right to a jury trial and to confront the witnesses against you in this case. Mr. Delgado, what that means, sir, is you could ask the state of Texas to bring their witnesses into open court to testify against you, where your lawyer can cross-examine those witnesses in front of a jury. During those proceedings, Mr. Delgado, Mr. Vail could call as many witnesses as he would like for you or on your behalf in front of that same jury. Mr. Delgado, do you understand, sir, you have those rights?
Yes, Your Honor.
You also understand, Mr. Delgado, that you do not have to give up those rights.
Yes, Your Honor.
All right, if you want to give them up, sir, you can, and you do it by filling out this paperwork called the Defendant's Waiver of Constitutional Rights and Court Admonitions. Mr. Delgado, did you go over this paperwork with your lawyer before you signed it?
Yes, Your Honor.
You understand what's in these documents?
Yes, Your Honor.
Wonderful, because these documents tell me that you understand what you're charged with, you understand the range of punishment, and then you further understand you have all of those trial rights we just talked about. It's telling me you want to give up those rights or waive them because you want to get into an agreement with the state of Texas on this case. Mr. Delgado, is that what you want to do?
Yes, Your Honor.
All right, great. Then I will approve your waivers and have them filed with papers in this cause. Mr. Delgado, evidently you have a plea bargain in this case. First thing you need to understand, I don't have to go along with your agreement, sir. However, if I don't go along with your agreement for any reason, I will allow you to withdraw your plea and start all over again. So anything you say in the next few minutes will not be held against you if that happens. Do you understand, sir?
Yes, Your Honor.
All right, Mr. Delgado, listen up. The state's going to tell us what the plea bargain is. Let's make sure it is what you agreed to. Go ahead, state.
It is a $0 fine plus court cost, 76 days in the Bexar County Jail, credit for time served, both time and money to run concurrent, and if it pleases the court, this will be a judgment satisfied. Additionally, Your Honor, as part of this agreement, the state will be taking into consideration and dismissing cause number 2024 CC 735-891, and we will also be taking into consideration and dismissing cause number 704-285.
Is that a 2024 case?
It's a CC, Your Honor. Sorry.
Okay. And I'm sorry then. Hang on, let me get rid of the 2024 here. And give me that, Keely, would you, that last one again, 7?
So the first, sorry, Your Honor, the first case is a CC7 case, and then the second one is CC 704-285.
285. Okay. Ray, is that the agreement?
It is, Judge.
Okay. Mr. Delgado, is that what you agreed to, sir?
Yes, Your Honor.
All right, Ray. Does Mr. Delgado have a rational as well as factual understanding of the charges and the proceedings against him?
He does.
Has he been able to assist you in the preparation of any possible defenses?
He has.
In your opinion, is he legally competent to waive his rights and enter into this plea?
He is.
Mr. Eric Anthony Delgado, are you a citizen of the United States of America?
Yes, Your Honor.
How do you plead to the Class B misdemeanor offense of theft of property, 100 to 750? Guilty, not guilty, or no contest?
No contest, Your Honor.
Mr. Delgado, you understand I can still find you guilty based upon that plea?
Yes, Your Honor.
Anybody force you, threaten you, put you in fear, or promise you anything to make you plead that way, sir?
No, Your Honor.
Doing so freely and voluntarily?
Yes, Your Honor.
Thank you, Mr. Delgado. I'll accept your plea of no contest. Upon that plea, I find you guilty of the Class B misdemeanor offense of theft of property, 100 to 750. I assess punishment at 0 fine, cost of court 76 days in the Bexar County Jail. Cost of court and the time will run concurrent. I will give you credit for time served, which means your judgment in this case is satisfied by the time you've already served. I will also take into consideration and dismiss 2024 CC 735-891 and County Court Case 704-285 in consideration for your plea in this case. Mr. Delgado, this was a plea bargain. You do not have a right to appeal. Mr. Delgado, you have any questions, sir?
No, Your Honor. Thank you.
All right. Take care of yourself. Stay well. All right. Merry Christmas.
Yeah. Merry Christmas,
Yes,
sir. Raymond.
Yes, sir. Take care.
All right. Thank you, sir. Do you know anything about being reinstated, though, Raymond?
Like I said, I think everything's fine, but I'll double check on that for you. Okay.
Okay. All right. Can you do that right now? Okay. All right. Now you checking something real quick for me. I didn't catch no new case or anything like that, Your Honor.
Yeah, you should be good.
That should be good, right?
Yes, sir. You should be good.
Yes. Yeah. There's no other cases.
Okay. All right. Remember, they're making me give these headphones up.
Yes, sir. No problem. Take care. Have a good Christmas.
Okay. Thank you.
Guy didn't want to leave you, right?
Well, he was just wondering if he was going to get out, Judge. I told him this was the only thing holding him. So unless he picked up something new, and that's why he was asking, did I throw any more charges?
Maybe he's just very suspicious of you. I don't know, man.
So he's good.
All right. Got those dismissals done. Thank you, Keely. All right, this must be Angela, all right?
That's right, Judge.
Hang on, let me find your paperwork if you would for a moment. County Court Case 725-341, State of Texas versus Angela Perez. Are you Angela Perez?
Yes.
All right, good morning. Could you raise your right hand, please? You swear to tell the truth, the whole truth, nothing but the truth, so help you God.
Yes.
Thank you, Ms. Perez. You can lower your hand. Ms. Perez, is it all right with you that we proceed by video conference?
Sure. Yes.
Is that okay with you? Okay, thank you. Then you are charged with the offense of theft of property 100-750. That is a Class B misdemeanor, Ms. Perez, punishable by up to 180 days in jail and up to a $2,000 fine. Do you understand?
Yes.
Ms. Perez, you have several legal rights. You have the right to remain silent and you have a right to a jury trial and to confront the witnesses against you in this case. Ms. Perez, what that means is you could ask the state of Texas to bring their witnesses into open court to testify against you, where your lawyer can cross-examine those witnesses in front of a jury. Ms. Perez, during that proceeding, your lawyer could call as many witnesses as he would like for you or on your behalf in front of that same jury. Ms. Perez, do you understand you have those rights?
Yes.
Do you also understand, Ms. Perez, that you do not have to give up those rights?
Yes.
All right, great. But if you want to give them up, you can. And this is the way you do it. You fill out this paperwork for me called the Defendant's Waiver of Constitutional Rights and Court Admonitions. Ms. Perez, did you go over this paperwork with your lawyer before you signed it?
Yes.
You understand what's in these documents?
Yes.
Wonderful, because these documents tell me that you understand what you're charged with, you understand the range of punishment, and then you further understand you have all of those trial rights that we just talked about. But you're telling me that you want to give up those rights or waive them so that you can get into an agreement with the state of Texas on this case. Is that what you want to do?
Yes.
Good. Then I will approve your waivers and have them filed with papers in this cause. Ms. Perez, evidently you do have a plea bargain in this case. First thing you need to understand, I don't have to go along with your agreement. However, if I don't, I will allow you to withdraw your plea and start all over again so that anything that you say in the next few minutes will not be held against you, Ms. Perez. You understand?
Yes.
All right, Ms. Perez, do me a favor. Listen up. State's going to tell us what the plea bargain is. Let's make sure it is what you agreed to. Go ahead, State.
It is a $0 fine plus court costs, 35 days in the Bexar County Jail, credit for time served, both time and money to run concurrent, and if it pleases the court, this will be a judgment satisfied. Additionally, Your Honor, as part of this agreement, the state will be taking into consideration and dismissing cause number CC 725342.
Okay, Ray, is that the agreement for Ms. Perez?
It is.
Ms. Perez, is that what you agreed to?
Yes.
All right, Ray, does Ms. Angela Perez have a rational as well as factual understanding of the charge and the proceedings against her?
She does.
Has she been able to assist you in the preparation of any possible defenses?
She has.
In your opinion, is she legally competent to waive her rights and enter into this plea?
She is, Your Honor.
All right, Ms. Angela Perez, are you a citizen of the United States of America?
Yes.
Ms. Perez, please tell me how you plead the Class B misdemeanor offense of theft of property 100-750. Guilty, not guilty, or no contest?
No contest.
Ms. Perez, you understand I can still find you guilty based upon that plea?
Yes.
Anybody force you, threaten you, put you in fear, or promise you anything to make you plead that way?
No.
You're doing so freely and voluntarily?
Yes.
Thank you, Ms. Perez. I'll accept your plea of no contest. Upon that plea, I find you guilty of theft of property 100-750, a Class B misdemeanor. I assess punishment at zero fine to cost of court 35 days in the Bexar County Jail. Cost of court and the time will run concurrent. I will give you credit for time served, which means, Ms. Perez, your judgment is satisfied by the time you've already served. Ms. Perez, this was a plea bargain. You do not have a right to appeal. Ms. Perez, do you have any questions?
No.
Okay, then you take care of yourself. All right, Merry Christmas.
Thank you.
Merry Christmas, Ray. Good seeing you, brother.
Merry Christmas, Judge. Merry
Always
Christmas,
a pleasure.
everybody. Take care.
Thank you.
Merry Christmas.
Well, Terry, what happened to, I got a couple other cases here.
All right, that's which one?
Dorantes Perdomo.
Perdomo,
Dorantes Perdomo.
that's gonna be set for trial, Judge, reset.
Right, and then Jay Thayer.
Thayer was dismissed.
Got it. All right. Let me hop off YouTube and then we'll get to the bonds.
Okay, gotcha.
Who's the attorney of the day?
Patrick Lamas, Judge, he's here.
Jesus, all right.
And then we have Timothy Young on a camera, Judge. He's one of our bonds.
Patrick, did you notice it didn't?
Okay, it's going to take me 1 second to get the next one. That was all I had for today, but let's just keep going for a couple more minutes. Let's not stop yet. I gotta resize this before I hit play. It's not that bad. It is not that bad. I just stopped because I forgot what I was doing. That stressed me out though. Okay. When I watch court cases, it's always sped up. When I'm doing the OJ trial, we always do that on 1.25. It doesn't sound that bad. It sounds pretty much okay. I must have kept it on 1.25 when I did that one and not realized it. But first I was stressed, but then I couldn't stop laughing at everything. And then we finished the docket. But this is not sped up. This next one is just court.
There was a history between the VRL.
Hold on, I
and
gotta make
George
sure you have
Robinson,
sound. And you
which I
do.
was not aware. But by responding to my friend's call for help, put myself in the middle of a volatile situation. Having done that, I feel responsible for not having been more de-escalate had injured. I want you to understand that I've known Max for almost 2 decades and have never seen him behave violently. I thought his actions were more for show or deterrence than anything, and I did not anticipate in any way what was about to occur. Had I known what Mr. Jacobs did next door, I
This
truly
is
believe I
murder.
would have responded differently than I did, because I did not have any ill will towards Mr. Robinson. I did not wish any harm upon him. I did not even know him as a person. Unfortunately, no amount of hindsight or regret will bring back Mr. Robinson to his level. I can never go back, change what I did that terrible morning. I can only pray that God will heal the pain I have caused, that he will be at peace for his family and friends. This incident has been a catalyst for me to work with become a better person, better father, a better member of our community. These goals go hand in hand. In order to accomplish one, we need to be successful at each. The first step is furthering my education. This includes enrolling in a program that will allow me to finish becoming a licensed electrician, along with pursuing a business degree at PCC and attaining certifications relevant to my field. Certifications such as NAPSEC and company-specific accreditor and solid accreditation. My educational goals extend beyond the scholastic, primarily strengthening my interpersonal skills such as communication, conflict resolution, empathy, and active listening. Working on these skills will increase my overall emotional intelligence and self-awareness, making me a more effective and dependable leader, business owner, and father. Another way I will work towards my goals is to become more involved in my community. By continuing to attend my church, volunteering in local outreach groups, mentoring the young men around me, and being an advocate for the victims of gun violence, I believe I can be a constructive member of and a positive influence on our wonderful city. In accomplishing these goals, I will be successful at the most important endeavor set before me, being a good father for my son, and providing him with a stable, healthy life filled with love. I know by taking these steps, I can model a life of integrity, compassion, and generosity, showing him the importance and value of life, to cherish his fellow man, and that true strength is helping
The value of
and
life,
providing for those that cannot do
to
so
cherish
alone.
your fellow man.
I will teach him
This is a
that
murder
violence is never the
sentencing.
answer. Through discretion and de-escalation, you can remove yourself from, you avoid a compromising situation like the one I found myself in. I agree with Ms. Joy, and I know that there is no sentence you can give me that will ever atone for what I took from her that day. And for that, I am eternally always hoping. I'm just so sorry. Cannot express it. That's all I have to say. Really.
Mr. Rizzo, I appreciate your comments. Mr. Johnson, who else would you like the court to hear from?
One family member, Judge, that'd be Mr. Rizzo's sister.
Hi, can you tell me your name?
Good morning. My name is Alisa Rizzo.
Thank you for being here.
Thank you so much for having me.
This is the murderer's sister.
I am speaking on behalf of the Rizzo family. Thank you so much for allowing the Rizzo family to provide a statement on behalf of Jacob Rizzo. I am Jacob's younger sister, and first and foremost, I want to acknowledge the profound grief of losing a loved one. To the mother of Mr. Robinson, I am so incredibly sorry for your loss. The loss of a son, a friend, and a father. After my own father's abrupt passing earlier this month, I've spent a lot of time reflecting on the importance of cherishing life. Our family understands the pain of having to say goodbye before you're ready, and I am deeply, deeply sorry that Mr. Robinson's family did not have the chance to say goodbye. The way we perceive and value life has forever changed, and I believe my brother has had time to reflect on the different actions he could have taken that might have led to a different outcome on June 19th, 2023. Every choice we make, no matter how small, shapes our reality. And Jacob has spent the past few years reflecting on what he could have done differently on that dreadful morning, just by taking a few more moments to assess the situation and use his discretion to consciously pause before responding. Growing up, my brothers and I were taught to value loyalty, faithfulness, courage, community, and authenticity. And I see those values reflected in Jacob and his friendships. He is fiercely loyal to his friends and family, and that is made obvious because he is the first person I and many others would call in the time of need. Jacob is the kind of person that will show up. If you need him, he will be there. However, because of the loss of a precious life, in June of 2023, my brother has learned to prioritize judgment and taking time to analyze situations before responding. Because of the deep remorse he feels for the loss of Jordan Robinson's life, Jacob now exercises curiosity and discretion in his friendships, his behaviors, and responses. Over the past few years, Jacob has remained hardworking, dedicated man, father, brother, and son while awaiting trial. Since his son Iroh's birth in May 2024, Jacob prioritizes being the best father he can. He wants to be the kind of father our father was. Courageous, devoted, genuine, honest, ambitious, and always striving to be better. Jacob now understands the pain that comes with the absence of a father, and he is determined to be present and nurturing figure in his son's life. Having experienced the loss of our father, Jacob now fully grasps the impact of a parent's absence would have on a child, and is deeply saddened that Jordan will be absent in his daughter's life. I have seen tremendous growth in my brother as he has learned to nurture his mental and spiritual health through therapy and by being an active member of his church. Jacob was on a journey to build a better future, and where he finds himself now, he is challenged to continue on this journey with a new passion to become a better version of himself, with increased wonder, creativity, strength, compassion, and love. He has been forever changed. Thank you so much for giving us the opportunity to speak on behalf of my brother.
I appreciate you being here as well.
Alisa Rizzo, ALYSSARIZO.
Mr. Walls or Mr. McCarthy, are the people seeking any restitution in this case?
Yeah, Your Honor, I think we're going to ask to keep it open. We need to confirm that there's no restitution to be sought by victims' family.
Okay. Mr. Johnson, anything else on behalf of Mr. Rizzo? Okay. So I've considered the statements made by everybody, the purposes of sentencing, the nature and the circumstances of the underlying case, and the history and the character both of Mr. Cagnoni and Mr. Rizzo. You know, I believe they both are remorseful at this point in time because things deteriorate. You know, so many of us had an opportunity to watch the various videos of the event in question over and over and over again.
Here we hear it. Here we go.
You know, this community has always been a supporter of Second Amendment rights, but with rights comes responsibility. And I understand that Mr. Jacobs was a friend of both of yours, and he asked for your help. But it was also clear that you were aware a conflict had occurred between somebody, maybe not specifically knowing Mr. Robinson, but somebody, and Mr. Jacobs' mother and stepfather. And that should have simply been left to law enforcement, but you didn't do that. All three of you showed up, you were prepared, maybe not to necessarily avenge the harm that occurred to Mr. Jacobs' mother and stepfather, but you were certainly ready to intervene if an opportunity presented itself. And you did. It did, and you did. You knew there was a problem, a possibility of a problem developing in this case, and it did. And the way you show up, armed, ready, a couple people wearing vests, it almost seems like you glorified this event. I understand you both feel otherwise now. Hindsight's 20/20. When I've looked at this video so many times, what I see is Mr. Robinson simply walking to his car. He's unarmed. Mr. Jacobs is wearing a vest. He's carrying the shotgun. He's following Mr. Robinson, and then he chases Mr. Robinson to the car. Mr. Robinson gets in the car, he locks the door, and Mr. Jacobs is striking the car with the gun several times, both sides of the car. And Mr. Robinson simply backs up. He's trying to get away from Mr. Jacobs. I don't recall what the distance was, but if I had to guess watching that video, it's 300 feet or more. And he backed up, just trying to get away from Mr. Jacobs, and crashes into one of your cars. And within just those couple of moments, you know, he was just trying to get away at that point. And both of you shot several times. Mr. Rizzo shooting Mr. Robinson, killing him, and Mr. Cagnoni shooting at the car. This is a situation that should have been left to law enforcement's discretion. That's why they exist. Granted, they weren't going to be there immediately, but your plan didn't work out so well either. And it's just unacceptable. So what I'm going to do with regards to both of you, I'm going to impose the same sentence. I'm imposing a sentence to the Department of Corrections. It's going to be for a period of 2 years. There's a 2-year mandatory period of parole. Mr. Cagnoni is entitled to 3 years credit for pre-sentence confinement. Mr. Rizzo is entitled to 85 days credit for pre-sentence confinement. You'll both be subject to the standard legislatively mandated fees, charges, and costs. I'll find there's possibly restitution, including interest due in an amount yet to be determined by the prosecution. I'd want the prosecution to file and serve on defense a proposed order reflecting the amount of restitution within 42 calendar days. Then if the defense objects to the amount of restitution sought, you could file an objection or request for a hearing within 10 calendar days of receiving the prosecution's proposed order. Obviously, both of you would spend less time incarcerated than the term I've announced here today. The actual time served would be influenced by a number of factors, including previous criminal activities, earned time for good behavior, earned time for correction education programs, credit for time served, and eligibility for community corrections programs. Mr. Saunders, Mr. Johnson, you both waive any further advisement with regards to your client seeking reconsideration. You'll advise them accordingly. Mr. Johnson? Okay. I wish everybody good luck.
The judge should get 2 years now. I just don't get it. I don't understand. Oops, that's wrong. All right, guys. It's just not right, but that's what happens in Colorado. They don't like people in jail in Colorado. Who knows? Maybe he'll get into a fight in jail and get 4 more years added. He wasn't, I think he got 2 years. I don't know. I don't even know. But that's Colorado. I'm going to start OJ now, and then we're going to get ready for tonight. All right, guys. Thank you so much for coming out. I appreciate it. I really, really do. Actually, if you're here for court, it's over now. So you can go. You can go. I'm going to start OJ in a few minutes. But, man, I'm going to talk for a little bit first. Kelly, are you still here? I can't wait to watch your son's games on Twitch. That will be fun. If you guys go to Twitch and watch her son, I've not seen her son. I don't know how her son plays games. I just know in general, gamers are a different breed. So, be prepared. Be prepared for some words. Some very offensive words if you go there. But that's just how they play. That's just how it is. It's fun, though. It's so much fun. Yeah, I've off for the next 8 weeks. So, don't try to keep up with me. If I put some content out and you want to watch it, watch it. But don't feel like you have to watch it all, because it's going to be hard for the next 8 weeks if you try to keep up with me. Just don't, because you'll burn out and then you'll leave. So don't, just watch what you want to watch and don't watch what you don't want to watch. I'm fine. It's fine. I would rather you guys stay than think, my God, this lady won't leave us alone. You know what I mean? But I have to put a lot out in the next 8 weeks. I have to. That way I don't have to go to work anymore. That's the whole goal. The whole goal is to not go back. But I will. I love that job. It's a good job. It's very hard on my hands. That's why I have this on. It's just to get it back into shape before I start again in 8 weeks. So I'm ready. And I'm strong enough. Yesterday, it was so embarrassing. I had a day yesterday. I started a pot of coffee without putting the pot under. I caught it right away, but still, there was coffee. Then we had these big bins of ice. I was getting a big bin of ice, and my hand couldn't grasp it. And it fell all over the floor. Ice everywhere. So that was yesterday. And then the end of the day, it's a huge dining room, and I have to vacuum it at the end of the day. So I get this real long extension cord. I don't know how long it is. So I'm going to girl guess a length, 300 feet. I could be off by whatever, because I don't know. It's just long. It's one of those things that you roll the extension cord up in this big thing. So I vacuum the floor, and then I'm trying to roll this extension cord back into the stupid thing. And it's getting heavier and heavier as I'm rolling, and the shift is done. So I'm dead tired. So finally I grab a chair and I sit down and I try to roll it, and I can't hold it. It's getting too heavy for me. And I've done this a million times before. I don't understand, but it's getting too heavy and I can't roll it. So I put it on my lap and I try to take nope, I could not. I couldn't roll it with me putting the weight down, because it had to be up in the air to roll it. So I put it on the floor and I try to roll it, because I can't hold it with my hands. I couldn't. There's like 20 feet of cord left. I'm sitting there in this chair looking at this thing. And finally my manager, she's like, Kathy, are you okay? I'm like, no. She goes, do you need help? I'm like, yes. And for anybody who knows me, for me to say yes in that situation was so hard, and it was instant. Before I even had time to think about it. Do you need help? Yes. I need this stupid cord because I can't do it. My hand will not let me do it. It was horrible. Horrible. I tried not using that handle. I tried everything I could. It was too heavy and bulky. And the cord was, you know, we use it every single day. Isn't that long of a cord? So it was like twisted. I couldn't do it. It was our last show. I knew I had off for 8 weeks. And my body is just like, you know what? I'm just done. Now I needed 1 more hour from you, sir. No. So my manager, my tiny little manager, she's amazing. She is just an amazing human being all around. She came and she just picked it up and rolled it while I went and did the easier task and put the vacuum cleaner away. Yep. Yeah, that was horrible. That was just a horrible way to end. But that's why I'm trying to get my hand back in shape. There's a tendon that's inflamed. So I have to I'm not allowed to move it at all. I think you can go get you can get a shot, like 1 shot. Like if I could just go to the doctor, you could get like 1 shot and it, you know, takes it down. But can't do that. I can't get that shot. So I have this brace, and it wasn't rigid enough for me, so I actually have a soup spoon shoved up in there so that I cannot move this thumb. That's all I have to do for like 2 weeks is not move my thumb. I can do it. I can. It's hard because I'm doing things with like just 4 fingers now. Like typing. And my phone use, forget it. I stopped using my phone, I don't know, 2 or 3 weeks ago. Like I use it only when I absolutely have to use it. I don't text. I haven't played a video game in forever on my phone. In like 3 weeks, that's forever for me. Because I was trying to fix my thumb, you know, the easy way, like stop using it. That didn't work. So now it's in jail. It's in jail for 2 weeks, maybe 3. I don't know. I just don't know. I don't know how to fix. All I'm doing is looking shit up on the internet and hoping Reddit knows what to do. But from what I read, once I get it fixed, you know, in the next 7 weeks, it'll be fine after that. It's not like it's going to reoccur. It's not like a forever. I am forever not able to use my hands again. It's just inflamed right now, and I just have to calm it down because I used it too much. But 8 weeks off. I got humongous plans for this 8 weeks off. Thumb-free plans that I'm going to do. And tonight is one of them. It's our new evening streams. So I'm pretty excited. It's a little worrisome because, you know, the big guys stream at 8 o'clock. But I'm not scared of them. I'm going to bring judges that no one has seen yet. I'm going to do my best to find some judges that no one's seen. I don't know yet. I don't know what I'm going to play yet. So who knows? I might play Judge Simpson. I can play whatever I want. It's my channel. But Kelly, I'm going to take time off and watch your son now. I really am. I'm excited to see it. I hope that you guys have a good day. I'm going to start OJ. We are this close to finishing OJ. We started last December, I think. We are this close to coming to the end. I don't know what I'm going to do with myself once OJ's over. It's consumed so much of my time, you know? But we're almost at the end of that. I will still be within my 8 weeks off when OJ ends. That was not a good idea. I need someone to stop me from doing projects like OJ Simpson trial. When I think, hey, this is a really good idea, let's do this. It'll only take 3 years to finish. Someone has to say, Kathy, no, don't do that. Just don't. I won't listen, though. All right, guys. Behave. Be good. I'll see you real soon. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for yourself.